May it please the Court, Counsel. The Wayne County Juvenile Court erred when it granted permanent custody to the Wayne County Children's Services Board, as it was against the manifest weight of the evidence based on what was presented at the trial. The proper course of action would have been for it to grant an additional 6-month extension of temporary custody. A judgment is against the manifest weight of the evidence when the court reviews the entire record, weighs all the evidence and all the reasonable inferences, considers the credibility of the witnesses, and determines that the finder of fact clearly lost its way and created a miscarriage of justice that requires the judgment to be reversed on a new trial order. In this case, a court cannot terminate parental rights under 2151-414 unless there is clear and convincing evidence of both of the permanent custody prongs in the test. It was against the manifest weight of the evidence because Wayne County failed to establish each one of those prongs. The court first decided to grant permanent custody based on the first prong on whether or not a child is not abandoned, orphaned, or in a public children's services agency for 12 of the last 22 consecutive months. A court must find in that case that the child cannot be placed with a parent in a reasonable time, or that the child should not be placed with a parent. The court in this case relied on only one factor, and that is to say that the parent has failed continuously and repeatedly to substantially remedy the concerns that caused the child to be removed from the parent's custody. In this case, the parent Rebecca Marty, did not fail to continuously and to substantially remedy the problems, as she had been complying with the case plan throughout this case. That's the point of the case plan, basically, to serve as a roadmap, if you will, to reunification. Now, in this case, mother was ordered to complete parenting classes. As the testimony showed by the caseworker, mother had completed not one but 2 parenting classes. The progress notes from this time period showed that the agency had felt that progress on that objective was substantial. There was a progress note there were 2 sets of progress notes between July and August, and these progress notes stated that mother was substantially complying with this objective. These progress notes also said that mother needed to continue to apply her parenting skills, implying that she was already applying them, she just needed to continue applying them. So
am I correct in my recollection that temporary custody was not initially awarded to the agency, but was awarded at several months afterwards when they determined that mother was allowing the maternal grandfather to see the child?
That's correct, Your Honor. There was an 8-month span while this case was going on where the agency did not have custody. It tried on 2 occasions, but was denied at both times.
So would that be the circumstance that brought the child into the custody of the agency?
I would argue not entirely. As the case had started out, there were similar concerns that had been stated to start the case. So all of these concerns were pretty much the same throughout the case. It was just this event that had prompted the removal.
And then what was the status of that particular issue at the time of the permanent custody?
When you say what was the status of the issue?
Was the maternal grandfather still in contact with the child at that point?
Not to my knowledge, no. Mother also had been required to complete a psychological assessment. Now, she had been assessed in July 9th and July 29th of 2014. She was required to complete individual counseling as a result. This counseling was in progress, and the caseworker testified that mother was consistently attending this counseling. Mother was also required to complete a substance abuse assessment. She had completed that in June 4th of 2014. Now, while she had slipped up and had used marijuana, she had also completed a second assessment. She had done all the legwork that she needed to do. She had talked to the assessor. She had answered their questions. There was an issue that she needed to complete a drug screen at the time, but she'd done all the other work prior to that to complete the second assessment. The final thing that she needed to complete was to secure safe and stable housing. Now, she had housing at the time of the permanent custody hearing. The agency did have an issue with that because the maternal grandfather had been in that house. But mother's testimony, as well as her sister's testimony, had stated that this grandfather would be asked to leave. So,
Well, if he's been providing significant amount of their financial support, then he's going to be asked to leave something he's been paying for?
well, that was an issue that there was some differing testimony on. The sister had said that he was not providing that financial support. Mother had stated that he was. However, as mother was living with her sister, it was her sister's home, I think the sister was in a better position to judge what support she was receiving from her father at that time. So based upon all of mother's progress here, mother was completing the case plan and working to remedy the concerns. Therefore, it was against the manifest weight of the evidence for the court to grant permanent custody based on this factor. That doesn't end the inquiry, of course. Even if the agency was able to establish this factor, they needed to also establish the best interest factors in the second prong. And we would argue that the agency failed to do that as well. The court relied on at least 4 factors: the interrelationship and interaction of the child with her parent, the wishes of the child, the custodial history of the child, and the need for legally secure permanent placement. The interaction and relationship of the child with her mother weighed in favor of mother. They were affectionate to each other. They were visiting. Mother was consistent with visits. Mother and child were excited to see each other. They talked to each other. And there was nothing inappropriate entered into evidence regarding these visits. Now, the agency had concerns. They had concerns over mother speaking to the child about the case, which was stopped once the caseworker had told mother about that. Mother even redirected her child about that issue. There was an issue with mother being in the same bathroom as her child. And Rachel never reported anything inappropriate, even though the agency felt that she was of an age that she could do so and would not hesitate to report. Mother had testified that she was merely comforting her daughter while she was sick. There was also an allegation that there was pornographic material on mother's phone. That had been unsubstantiated. The agency looked into it and didn't find it. So that factor weighs in favor of mother in this case. As to the wishes of the child, it was clear from the record, including the fact that there was an attorney appointed for the child, that Rachel wanted to go back with her mother. The guardian ad litem recommended against it. And this court in INRI ET, CT, or CD, and CRD had found a similar conflict where the GAL had recommended that a 7-year-old go into the agency's custody at that point, and found that in that similar issue, the factor did not weigh in favor of the agency. It weighed in fact in favor of mother. In that case, the motion for permanent custody was ultimately overturned. The custodial history did not weigh in favor of the agency. The child was in custody of the agency for 9 months at the time of the permanent custody motion being filed, and as I stated before, she was in mother's custody for 8 months, and prior to that she was in mother's custody without the agency involvement. Finally, the legally secure permanent placement did not weigh in favor of the agency, as it is implicit, this court stated in INRI AW, it's implicit in that factor that the agency showed that a permanent placement would result from a grant of permanent custody, and that wasn't what happened here. In fact, the foster mother testified that her and her husband did not get into this to adopt children. So there was no permanent option there. It could be overturned, or it could be changed within a simple 2-week notification. In addition to that, there were 2 other permanent placements that could have been explored, in addition, especially if there was a 6-month extension. The child's maternal aunts, Jennifer Yost and Jessica Smith, could have been looked into. At the time of the permanent custody hearing, there would have been no problem finishing up the home study that was being conducted over Jennifer Yost. The only thing that was holding up that was the agency's procedures in completing the home study. They were waiting on a background check and would not actually go out to the home until that was completed. As for Jessica Smith, her home study had been denied back in 2014. over 12 referrals, that none of which bared any cases, none of those resulted in any cases, 9 of which were actually screened out. And the agency's alleged fraud, or the alleged fraud that the agency felt was happening. There was an issue with mother, or the aunt's benefits. The agency felt that there was some misreporting of income, but never really fully looked into that issue, never really touched base with the Department of Job and Family Services to see whether that was true. So in this respect, this factor does not weigh in favor of the agency. As these factors weigh more in favor of mother, the best interest factors were not established by the agency. What should have happened would have been a temporary, another extension of temporary custody. Now, that's appropriate when it's in the best interest of the child, which, as I've stated, it would have been in the best interest of the child to hold out for reunification, because those factors did not weigh in favor of the agency, but in favor of mother. And if there had been substantial additional progress on the case plan since the first extension. With the additional progress, as of January 12, 2015, when the first extension was granted, mother had not initiated parenting classes. There were no recommendations available for her psychological assessment. There were no recommendations available for her drug and alcohol assessment. Individual counseling showed no progress, and mother needed to maintain housing, but the caseworker at the time was unable to verify the housing.
Why is that?
That it wasn't clear from the record why they were unable to verify. So, as far as what additional progress happened, mother had completed not one but 2 parenting classes since then. There didn't seem to be any evidence presented that mother continued to make 0 progress in her counseling. The second drug and alcohol assessment was completed, but for a drug screen, and mother's home was able to be verified. In fact, the caseworker even testified that but for this grandfather issue, the home could very well have been adapted to suit Rachel's needs.
And counsel, you're in your 3 minutes if you want to say that.
Thank you. Just one point before that. The other additional thing for a 6-month extension is to effectuate a permanency plan. That could have been effectuated by extending the case plan to see where Ms. Yost's home study was. So I would argue that the agency did not meet its burden, and the second 6-month extension should have been granted. Thank you.
Good morning, Council Zeus, Ms. Marty. May it please the court, my name is Melody Bryant. I represent Children's Services in this matter. Children's Services asserts that the trial court's permanent custody finding was supported by clear and convincing evidence. The agency presented sufficient evidence to satisfy both prongs of the statutory requirements for permanent custody. The first being that the child could not be placed with either parent within a reasonable time, nor should she have been placed with either of her parents. As appellant had already discussed, the court did rely on the E-factor number 1. Despite reasonable case plan services, mother failed to remedy the concerns that initially brought the child into care, and the agency argues that the initial concerns that brought this child into care, there were several concerns. The main being that the child had been sexually abused. That was reported by mother. She believed that to be true. The agency also believed that to be true. There were also concerns with mother's mental health as well as the condition of the home. Throughout this case, the agency did create a case plan to address those specific concerns, created a case plan developed to help mother reunify with the child. Mother did participate in some of these services. However, some of the services were initiated quite late in the case, one being parenting classes. At the time of the permanent custody hearing, mother reported that she had completed 2 classes. One was an online parenting instruction, which the agency typically does not accept as sufficient unless they're able to review that material and determine whether that meets the requirements. They were unable to do that in this case due to the late completion of that program, as well as some difficulty making contact with mother. She also reported at the time of the permanent custody hearing that she had completed classes. The agency did attempt to confirm that completion. They needed to find out more about that program. It was not a local program. They contacted that program. They attempted to get information regarding mother's completion. Though I don't think they doubted that she completed it, they wanted more information about what topics were covered, whether mother made progress, and whether that class made a difference. The agency asserts, I think, as an overall theme that compliance with case plan objectives does not necessarily equal progress. It doesn't necessarily equal a remedy of concerns, and in this case, despite mother's participation in some parenting instruction, it did not appear to remedy the concerns that initially brought the child into care. One of the major concerns the agency had was mother's mental health. That was supported by Dr. Bowden's testimony and report, where she diagnosed mother with major depressive disorder, recurrent, severe without psychotic features, post-traumatic stress disorder, and dependent personality disorder with strong avoidant traits. I think more concerning is the fact that Dr. Bowden opined that it would be difficult for mother to complete a case plan successfully because of these mental health challenges. Additionally, she found that it would take mother years of consistent therapy to remedy these concerns. Unfortunately, during this case, mother had not made progress in therapy, and at the time of the permanent custody hearing, she testified that she had only been attending therapy about 50% of the time. So despite her engagement in therapy, mother did not make the sufficient progress necessary for the agency to believe that the child could be returned safely to her care within a reasonable amount of time. Despite these services, mother continued to maintain relationships with individuals that were concerning, specifically concerning because of the sexual abuse allegations, both that the child had been sexually abused, as well as mother's own assertions and allegations for many years that her father had sexually abused her. The agency was very concerned with this, very concerned with mother's allowing the child contact with maternal grandfather, and also concerned with mother's own contact with this individual. Mother also maintained contact with an individual that she believed had sexually abused her child. And even though that individual was not residing with her at the time of the permanent custody hearing, she did appear to be reliant on him for financial support and testified about that support. She also testified that she was significantly reliant on her own father financially. She resided in the same home. She testified that he provided all of the financial support for the family. Appellant answered a question about that financial support and said that there was a discrepancy in testimony. While mother testified that she was entirely reliant and that he provided a great deal of financial support, her sister testified that he did provide financial support for the family home, but she contested that he provided the rent money. So she did say that he provided financial support for the home, and that discrepancy wasn't, I don't think, as significant as the appellant answered. The agency also agrees that significant or sufficient evidence was presented to support the best interest factors. The appellant argues that these factors weigh in mother's favor, but the agency disagrees. The court did look at each of the statutory factors, and the agency presented evidence with regard to the child's relationship with her mother. Even though every witness that spoke on this issue did acknowledge that mother loves and cares for her child and acknowledge a bond between the two, there was also evidence that their relationship was not a healthy parent-child relationship, and that the child very much was concerned about caring for her mother, and that the mother relied on her for support as well. The therapist, as well as the foster mother and Dr. Bowden, described the child as parentified, and that being concerning, considering her relationship with her mother. The agency also presented evidence regarding the child's lack of relationship with other family members, as well as her positive relationship with the foster family, her ability to bond with this family and to adjust in a healthy way. The agency presented evidence that the child had a positive relationship with her therapist, which was very important for this child, and that positive relationship did not occur or develop until the child was in foster care and was attending therapy regularly. After the child attended foster care, she also developed relationships and friendships in school, and her behavior was described as having improved in this way. The agency asserts that the relationships she maintained that were positive were as a result of her being outside of mother's care. Appellant suggested to the court that the child's wishes were as simple as she wanted to go home, but the record reflects otherwise. This child wanted to go home with mother under certain conditions. That was expressed by her attorney as well as her guardian ad litem, who seemed to suggest in the hearing that she didn't agree a conflict existed. The child wanted to go home with mother if mother was not residing with Jason, who's the individual who had sexually abused her, and as long as she could be a child and mother could be a mother. There unfortunately was not evidence to suggest that this relationship had changed or had developed into a more appropriate parent-child relationship. The child had been in the agency's temporary custody since August 13th of 2014. I think what's significant here is even though that's not as long of a time period as this court sometimes reviews, once the child was removed, the trial court was never able to return her to her mother's custody. Mother also testified about a time period in 2010 where the child had not been in her custody. Regarding the child's need for permanency, the agency asserts that permanency cannot be achieved for this child without a grant of permanent custody. The agency provided sufficient evidence that mother could not provide a permanent home. On the day of the permanent custody hearing, she resided in a home with her sister, as well as the maternal grandfather. She had no independent source of income. She was reliant on others for income, and she was unable to provide that permanency. She also has physical ailments, I think, that made that difficult for her, made it difficult for her to obtain and maintain employment. Neither aunt could provide permanency. The agency did consider both of these individuals for placement. One, Ms. Yost, there was a pending home study. The agency had attempted to look into this individual sooner in the case, and Ms. Yost did not comply with the requirements of the home study. It was not completed at the time of the permanent custody hearing because she had not complied when they initially asked her to comply. The other aunt, Ms. Smith, the agency had completed a home study of this individual and had denied it. More significantly, though, at the time of the permanent custody hearing, the maternal grandfather was residing in her home. She testified that she was not able to take the child on the day of that hearing. Neither of these individuals had a motion pending before the court for legal custody of this child, and neither of these individuals was able to take her into their home on that particular day. So those options were not available to the court. As a part of that argument, the agency acknowledges that it also has to show the court that it can achieve permanency through the permanent custody. There's a case cited in the appellant's brief, In Re A.W., and I'd like to take the opportunity to distinguish the facts in this case from that case. The agency had not found an adoptive placement for this child at the time of the permanent custody hearing. However, they had found an indefinite home for her. The foster family, they were willing to maintain her indefinitely until a permanent placement could be found. There was no evidence to suggest it would be difficult to find permanent placement for this child, and that's the fact that distinguishes this case with In Re A.W. In that case, the child was placed in a mental health treatment facility. She had significant mental health challenges and uncontrollable behaviors that made it very difficult for the agency to find her a placement outside of that treatment facility. They hadn't been able to do that in that case. They had looked for foster placement, had not been able to obtain it. And in that case, the mother was advocating for a PPLA placement and not for the child to be returned to her home. Again, I think the evidence that was presented suggests and weighs in favor of the agency being able to find a permanent placement for this child. Her behaviors had improved. She was doing well in the home, and there were no concerning behaviors at the time of the permanent custody hearing. The agency believes as a result of her consistent therapy and stability in the home. In addition to the statutory factors, the court did consider many of the additional factors under subsection E and found again that the mother failed to remedy the concerns that initially brought the child into care. And I believe that judgment entry really focused on the fact that the court didn't believe mother would continue to keep this child safe in her home, that she hadn't, despite her progress and case plan objectives, she hadn't acknowledged the harm or the danger that her father presented to the child. She hadn't acknowledged the harm or the danger in relying on these individuals financially, and the court didn't believe that she would keep this child safe. The agency agrees with that and believes that there was sufficient evidence for the court to grant the permanent custody motion. Because there was sufficient evidence, because prong 1 was met and it was in the best interest of the child to be in the agency's permanent custody, the court did not abuse its discretion in denying the 6-month extension.
Thank you, counsel. You have about 2.5 minutes.
Thank you, Your Honor. Briefly, with regard to the permanent placement and the agency's distinguishing of AW, the key word in Appleby's statement is indefinitely. This is definitely not permanent. It's not a permanent home when you call that home indefinitely. Anything could happen in the 6 years that this child could have been there between now and the child's 18th birthday.
Doesn't she have, at her age, doesn't she have the option, the opportunity to also weigh in on where she would go for permanent placement?
And I believe she did. She wanted to go back with her mother.
No, I mean, if she were in fact to be placed in permanent custody agency, she would have some say as to what family she was adopted into at some point, wouldn't she?
I believe she would. And that's not necessarily saying that she would be there at the current home that she's at.
Well, I think that wasn't an option, was it?
At this point, no. So the agency would still need to look for a permanent placement, a permanent home for this child. So they could run into the same circumstances that they did in AW. They can't find a home that would either take the child or that the child would weigh into wanting to be there. So this home is definitely not a permanent option. The agency did not present a permanent option in this case. With regard to the parenting classes, again, as Mr. Cheek at the trial had presented testimony from the caseworker stating that, or implying that there was nothing that said, excuse me, that these online classes that mother had taken were unacceptable. As those progress notes again showed, mother was substantially complying with the case plan at that time, with that objective. As to the relationship of the child, again, yes, the child did have a good relationship with her foster family, but again, that family's not permanent. And as the agency had stated that they felt that the relationship between mother and the child was inappropriate because of how the child felt about the mother, what child isn't concerned about their parent? The parent is also going through this, they would normally be concerned. So I would submit that it's not necessarily a parenting, the child did not necessarily feel parented, or as a parent, but was really concerned with her mother. At the time of the permanent custody hearing, she also was not residing with the other person involved, this Jason Bomey. There was no testimony saying that she was. Again, I would reiterate that the agency did not meet its burden, that a grant of permanent custody was against the manifest weight of the evidence, and that a second 6-month extension should have been granted instead. Thank you.
The court will take the matter under advisement. A written opinion will issue and be sent to both sides, as well as you can look on our website for it. Thank you.
Thank you.